Welcome to an introduction to HIPAA, Health Insurance Accountability and Portability Act. Disclaimer. This training should not be considered legal advice concerning your individual and business responsibilities with regard to HIPAA. This course is a general introductory course which covers some basic concepts of the Health Insurance Accountability and Portability Act. The purpose of this course is to introduce assisted living facility staff to the existence of HIPAA and its key concepts. We suggest that you consult legal representation with regard to your obligations under HIPAA and specific implementation requirements. HIPAA Basics for Providers, Privacy, Security, and Breach Notification Rules. Please note, the information in this publication applies to HIPAA-covered entities, which include most healthcare professionals and healthcare organizations, as well as their business associates. When "you" as is used in this publication, we are referring to these persons and entities. History. Prior to the invention and adaptation of the Internet, most personal medical records were recorded on paper or saved on a computer disk and stored or locked in cabinets. As the Internet evolved, it became an essential component of healthcare, business, and services. In such, the need to establish a set of standards for how these records were securely handled and protected became integral. Continued. The challenge of protecting privacy and security of health information is enormous. Many people must have access to a patient or resident's healthcare information, including doctors, nurses, technicians, clerical and administrative staff, as well as the contracted personnel in other businesses involved in providing healthcare. For example, health plans, medical equipment, supply businesses, billing services, research departments, and pharmacists. According to the American Health Information Management Association, an average of 150 people from nursing staff to X-ray technicians to billing clerks have access to patients' medical records during the course of a typical hospitalization. HIPAA becomes law. In 1996, the federal government passed a law that creates national standards to protect patients' medical records as well as other personal health information, also known as PHI. This federal legislation is called HIPAA, Health Insurance Portability and Accountability Act. The Health Insurance Portability and Accountability Act, Privacy, Security, and Breach Notification Rules protect the privacy and security of health information and provide individuals with certain rights to their health information. This training discusses the following: the Privacy Rule, which sets national standards for when protected health information may be used or disclosed; the Security Rule, which specifies safeguards that covered entities and their business associates must implement to protect the confidentiality, integrity, and availability of electronic protected health information, or EPHI. The Breach Notification Rule, which requires covered entities to notify affected individuals, U.S. Department of Health and Human Services, and in some cases the media, of a breach of unsecured PHI. You play a vital role in protecting the privacy and security of patient information. This training gives you an overview of the rules, and it outlines the information protected by and who must comply with those rules. HIPAA Privacy Rule. The HIPAA Privacy Rule establishes standards for the protection of PHI held by health plans, healthcare clearinghouses, those healthcare providers that conduct certain healthcare transactions electronically, and their business associates. The Privacy Rule gives patients important rights with respect to their health information, including rights to examine and obtain a copy of their health records in the form and manner they request, and to ask for corrections to their information. Also, the Privacy Rule permits the use and disclosure of health information needed for patient care and other important purposes. Privacy rules identify what information is protected and define when and how that information may be used and disclosed. Protected health information. The Privacy Rule protects individually identifiable health information called PHI. held or transmitted by a covered entity or its business associate in any form, whether electronic, paper, or verbal. PHI includes information that relates to all of the following: the individual's past, present, or future physical or mental health or condition, the provision of health care to the individual, the past, present, or future payment for the provision of health care to the individual. PHI includes many common identifiers such as name, addresses, birth dates, and social security numbers. Please visit HHS HIPAA Privacy Rule webpage for more information, or you can click on the link above the video presentation. HIPAA Security Rule Technical Aspects. The technical aspects of the HIPAA Security Rule include access control. A covered entity must implement technical policies and procedures that allow only authorized persons to access electronic protected health information. Audit controls. A covered entity must implement hardware, software, and/or procedural mechanisms to record and examine access and other activity in information systems that contain or use PHI. Integrity controls. A covered entity must implement policies and procedures to ensure that ePHI is not improperly altered or destroyed. Electronic measures must be put in place to confirm that ePHI has not been improperly altered or destroyed. Person or entity authentication. In general, authentication ensures that a person is in fact who he or she claims to be before being allowed access to ePHI. This is accomplished by providing proof of identity. Transmission security. A covered entity must implement technical security measures that guard against unauthorized access to electronic personal health information that is being transmitted over an electronic network. Security rule continued. The security rule does not dictate security measures, but requires covered entities to consider all of the following: size, complexity, and capabilities, technical, hardware, and software infrastructure, the cost of security measures, the likelihood and possible impact of risk to ePHI. Covered entities must review and modify security measures to continue protecting ePHI in a changing environment. Please click on the link above the video presentation for more information. HIPAA Breach Notification Rule. The HIPAA Breach Notification Rule requires covered entities to notify affected individuals, HHS, and in some cases the media of a breach of unsecured PHI. Most notifications must be provided without unreasonable delay and no later than 60 days following the discovery of a breach. Notifications of smaller breaches affecting fewer than 500 individuals may be submitted to HHS annually. The Breach Notification Rule requires business associates of covered entities to notify the covered entity of breaches at or by the business associate. Who must comply with HIPAA rules? Covered entities and business associates, as applicable, must follow HIPAA rules. If an entity does not meet the definition of a covered entity or business associate, it does not have to comply with HIPAA rules. In the following slides, we'll discover who and what type of businesses would be considered covered entities. Covered entities electronically transmit health information. Covered entities include covered healthcare providers, health plans, and healthcare clearinghouses. The following covered entities must follow HIPAA standards and requirements. The first one is covered healthcare providers. They are described as any provider of medical or healthcare services or suppliers who transmit any health information in electronic form in connection with a transaction for which HHS has adopted a standard, such as chiropractors, clinics, dentists, doctors, nursing homes, pharmacies, psychologists. But what about assisted living facilities and long-term care facilities? Is your facility a covered entity? Well, it depends. On the next few pages, we'll be going into more detail, and there's a flow chart that can help you determine if you're a covered entity. When answering the questions, facilities should be aware of any long-term care funding programs provided by the state or federal government that your facility participates in. The first question is, does the participating in such business or agency submitting electronic claims for healthcare? In doing so, your facility could be considered. If the answer is yes, you move down to the yes box and then move over. It says, does the person, business, or agency transmit any covered transactions electronically? If the answer is no, then you move on and you are not a covered entity. If the answer was yes, then you could be considered a covered entity. Covered entities also include health plans, any individual or group plan that provides or pays the cost of health care, such as company health plans, government programs that pay for health care, such as Medicare, Medicaid, and the military and veterans health care programs. Health insurance companies, health maintenance organizations, or HMOs. They also include healthcare clearinghouse, a public or private entity that processes another entity's healthcare transactions from a standard format to a non-standard format, or vice versa, such as billing services, community health management information systems, repricing companies, and value-added networks. A business associate is a person or organization other than the employee of a covered entity that performs certain functions on behalf of or provides certain services to a covered entity that involve access to PHI. A business associate can also be a subcontractor responsible for creating, receiving, maintaining, or transmitting PHI on behalf of another business associate. Business associates provide services to covered entities that include accreditation, billing, claims processing, consulting, data analysis, financial services, legal services, management administration, utilization review. Note, a covered entity can be a business associate of another covered entity. If a covered entity enlists the help of a business associate, then a written contract or other arrangement between the two must A. detail the uses and disclosures of PHI the business associate may take, and B. require the business associate safeguard the PHI. It's your responsibility. You must respect confidential information about residents and use electronic protected health information only to perform your role in a facility. It's your responsibility to be sure patient information is only given or disclosed to those who with appropriate permission. What should you consider to be protected health information? All information that identifies an individual is considered confidential. This includes, but is not limited to, name, address, date of birth, phone, fax numbers, social security number, medical record number, and photographs. It also includes nursing and physician notes, as well as billing and other treatment records used during a patient or resident's visit to a hospital or assisted living facility, long-term care facility. Be aware. Electronic communications such as faxes, emails, and computer printouts may contain patient information. Take precaution to ensure that these types of communications get to their intended destination. Often there's a lot of paper that contains confidential patient information. Make sure to keep this paper out of the public view. Do not leave documents where the public can easily access them, even accidentally. Do not leave your papers or any medical information anywhere that it can be seen by others. For example, don't post notes about residents in an area that can be accessed by unauthorized people. It's best to use number identifiers for residents instead of their actual names. When documents containing patient information are no longer needed, shred them or dispose in designated containers. Long-term care considerations. Often in assisted living or long-term care environments, residents form close relationships with each other. Since they spend every day with each other and share their stories, residents can be very aware of personal and private medical information. If a resident becomes ill, their friends in the facility may ask detailed questions about their condition. Be aware of HIPAA guidelines in these situations. Note, your residents are not subject to HIPAA. Only your employees and workforce are covered. It is imperative that your staff understand their boundaries with regard to protected health information with proper authorization. HIPAA guarantees several rights to patients and residents. Number one is right to privacy. Next, right to confidential use of their health information for their treatment, billing process, and other healthcare operations such as quality improvement. Right to access and amend their health information upon request. Right to provide specific authorization for use of their health information other than for treatment, billing, and other healthcare operations. Right to have their name withheld from patient directories. Right to request that information is not given out concerning their care to specific individuals, including the right to opt out of patient or resident directories, name not listed as being present in a facility other than for treatment, billing, and other healthcare operations. And the right to request that individuals are not told about their presence in a facility. HIPAA authorization. There's two types of authorization. One is written authorization. A written authorization is a form signed by the patient for the use and disclosure of specific PHI that are not related to treatment, payment, or healthcare operations. There are some uses and disclosures where an authorization is not required. When in doubt about what information is required to have a signed authorization for release, just ask. Verbal authorization. Verbal authorizations are valid only if being used to disclose information for treatment, payment, or healthcare operations as outlined under HIPAA. Verbal authorization is never sufficient to disclose substance abuse, HIV, mental health, treatment information unless to not do so would jeopardize the care of the individual. Generally speaking, it is recommended that a written authorization be obtained from the individual. HIPAA release form. A facility authorization form should include a description of how their PHI may be used by the facility, and 2, a comprehensive list of others to whom their healthcare information may be disclosed. The notice must be given to the patient on the first treatment date or as soon as is practical in an emergency situation. Documentation. Since HIPAA privacy regulations require we must furnish patients with a disclosure authorization, it is very important that all disclosures, whether pursuant to written or verbal authorization or not, are documented in the patient record, and that there is a method for assembling this information should it be requested. Facilities should create a form to document unauthorized disclosures and have a process to follow. Unauthorized disclosures. Some of the biggest threats to patient privacy is unintentional disclosure of information. For example, discussing a resident where other residents or visitors may overhear, such as in elevators, hallways, or in dining areas. Leaving sensitive information out where other residents or patients or visitors can see it. For example, post-it notes or other notes visible to the public. Another threat to patient privacy is when a workforce member intentionally uses or discloses information in an unauthorized way. For example, copying information and taking it home, removing medical records from the facility and giving them to others who have no legal right to them, deliberately sharing information with unauthorized persons, family members, friends, or news reporters, using confidential information in gossiping about patients, leaving a computer unattended after logging in to an application which may hold resident or patient EPHI, sharing passwords with others or leaving passwords around a computer. Unauthorized disclosures. It is essential that everyone who provides care and services to patients or residents be aware of what is going on in their surroundings to ensure that confidential information is only shared with those who need to know and at the minimum level necessary to enable them to carry out the duties and responsibilities safely, effectively, and efficiently. Always be aware of where you are, who is around you, and what information can be seen or heard. It may not be possible to ensure absolute privacy, but reasonable measures need to be taken to minimize the chance of incidental disclosures to others. Don't browse through a patient's chart and other files out of curiosity. Access only the portions of a medical record you need to perform your specific assigned responsibilities. Verify identity. Before you can release information about a resident, you must first confirm the identity of the person requesting information about the patient, whether in person or by phone or in writing. What methods can be used to verify identity? A photo ID, or information that only the patient would know and which you can confirm, such as the patient's middle name, date of birth, or last 4 digits of the resident's social security number. Enforcement. The HHS Office for Civil Rights enforces the HIPAA privacy, security, and breach notification rules. Violations may result in civil monetary penalties, in some cases criminal penalties enforced by the U.S. Department of Justice may apply. Common non-compliance issues include impermissible PHI uses and disclosures, lack of PHI safeguards, lack of patient access to their PHI, use or disclosure of more than the minimum necessary PHI, lack of administrative ePHI safeguards. Case example. The following are actual case examples. Settlement. 2 covered entities inadvertently posted ePHI for 6,800 individuals on the web, including patient status, vital signs, medications, and laboratory results. The investigation found that neither entity made efforts to assure the security of the server hosting the ePHI or confirmed it contained adequate software protections. Neither entity developed an adequate risk management plan that addressed potential threats and hazards to ePHI. The entities agreed to pay a combined settlement of $4.8 million and enter into a corrective action plan. Criminal prosecution. A former hospital employee pleaded guilty to criminal HIPAA charges after obtaining ePHI with the intent to use it for personal gain. He faced up to 10 years in prison. HIPAA complaints. What you need to know. Anyone can file. Anyone can file a complaint alleging a violation of the privacy or security rule. HIPAA prohibits retaliation. Under HIPAA, an entity cannot retaliate against you for filing a complaint. You should notify OCR immediately in the event of any retaliatory action. You have reached the end of the HIPAA training. Thank you for listening, and you may close out this video and proceed on to the next section.